that a yes?
Yes, Your Honor.
Okay, asked you all to do on the lunch break.
Oh, yeah, we have another.
Okay, anything?
No, Your Honor.
Okay.
Judge, I'm just looking at the 11.10B, lewd or lascivious battery, the substantive instruction under sexual activity. Ms. Johnson has informed me that's the standard, but it just doesn't read right to me. The second sentence, that language of another, it seems like it would be better to read by the sexual organ of another or the vaginal penetration by any other object. With the of another out.
I tend to agree with your position on that. So it means that essentially we read sexual activity means the vaginal penetration by the sexual organ of another or the vaginal,
Of another by any
of
other
another
object.
by any other object. It means the vaginal penetration of someone other than the defendant by any other object.
How about or the vaginal penetration by any other object by another? Or I could read it as it is, but just put by instead of of.
I think that the way this is the standard, I think it makes perfect sense.
You do?
Yeah.
So, or the vaginal penetration by any
Other
other
object
object
by another.
by another.
Of another by another?
It doesn't. I understand it, but maybe it does make more sense to make it a little clearer. I don't. To me, they basically read the same, but I don't have a problem with changing it. So it would read: sexual activity means the vaginal penetration by the sexual organ of another, or the vaginal penetration by any other object by another.
Your Honor, the defense preference is to keep the standard.
Actually, I'm going to leave it as is. Okay, any other requested changes? For the record, the defendant is present.
Judge, on the sexual battery and on the lewd or lascivious battery, where it says victim less than 16 and victim less than 12 have been over 18, can you put parentheses around that?
Like all throughout the jury instructions?
Yeah, that's how typically it is.
Well, in the instructions you sent me, it wasn't like that. But I need to go back and do that now?
If you want to send it to me, Judge, I'm happy to do it.
Yeah, but I got to read it to this jury in 10
Oh, I'm
minutes.
Judge, the other thing I was going to suggest in felony murder, both first degree and third degree, is adding the language of attempt to track the statute while engaged in the commission. or attempted commission of sexual battery or aggravated child abuse.
Now we're throwing in attempt.
Yeah, I just noticed that wasn't in there.
Well, wasn't, and so now we gotta give them what, an attempt instruction too?
I just know in felony murders, that's pretty much standard.
Well, it wasn't standard in the ones you all sent me, again.
I apologize for that.
Take a look at the standard instruction. And again, it would have been helpful yesterday, if someone would have caught this, so I could do this last night as opposed to at the last minute. It says give 2A, 2B, and/or 2C as applicable. I'm looking at the standard instruction. To prove the crime of first-degree felony murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Felicia Williams is dead. 2A, while engaged in the commission of the felonies alleged caused the death of Felicia Williams. B would be while engaged in the attempt to commit felony alleged caused the death of the victim. Or C is while escaping from the immediate scene after committing. So did you allege attempt in your indictment?
No, I didn't, Your Honor. But I don't think the law requires you to allege it. You read felony murder 78204, it reads 78204 sub 1, sub 2, sub 1A, sub 2, when committed by a person engaged in the perpetration of or in the attempt to perpetrate any, and that lists the enumerated violent crimes.
Defense, what's your position?
I'm not requesting it anymore.
Okay.
I think you just give a standard attempt instruction.
Okay. So it would be 2 would read, while engaged in the commission of sexual battery, victim less than 12 and defendant over 18, and/or aggravated child abuse, Granville Ritchie caused the death of Felicia Williams, or, right?
Correct. Or you could combine it into one paragraph. While engaged in the commission or attempted commission of sexual battery. That's the way it reads in the statute. The substantive statute.
Okay, so we'll read felony murder, first degree, the second element, while engaged in the commission or attempted commission of sexual battery, victim less than 12 and defendant over 18, and/or aggravated child abuse, Granville Ritchie caused the death of Felicia Williams. Now I got to throw in the attempt instruction.
Right. And then in the third degree felony murder instruction, it would read the same. Or should.
Are you allege an attempt for both the sexual battery and the aggravated child abuse?
Yes.
So, do you want the attempt definition within the definition of felony murder first degree? Or you want that?
You could read it at the end of the substantive instructions.
as to all of the 4 felonies it applies to for felony murder.
And I'm looking at the extended instructions, I believe the attempt instruction should be given it says to give it immediately after. So 2B, if 2B is given, then you give it immediately after, not at the end.
That's fine.
Okay, so attempt to commit a crime. To prove the crime of attempted, so I might probably just give it twice, after first-degree felony murder and after third-degree felony murder. To prove the crimes of attempted sexual battery. Prove the crimes of attempted sexual battery, victim less than 12, defendant over 18, and aggravated child abuse. The state must prove the following 2 elements beyond a reasonable doubt. In order to prove the defendant attempted to commit the crimes of tell the jury, I apologize. We had something come up and I'm working on it.
Okay. That's what I was going to ask you if you wanted to say something.
Yes. This is really time consuming. It's going to take more time than just 5 minutes. Because now I need to know that how much of the attempt instruction the defense wants me to read. Take a look at it, if you don't mind, Mr. Gunvon, 5.1.
Factually, it doesn't really apply.
All right, so currently it reads as follows. Under attempt to commit a crime under felony murder first degree. In order to prove that the defendant attempted to commit the crimes of sexual battery, victim less than 12, and defendant over 18, and or aggravated child abuse, the state must prove the following beyond a reasonable doubt. The state must prove the following. I would put in, it just says to prove the following, but there's 2 elements to it, so I would put in 2 elements. Beyond a reasonable doubt. 1, the defendant did some act toward committing the crimes of sexual battery, victim less than 12, and defendant over 18, and or aggravated child abuse that went beyond just thinking or talking about it. And 2, he would have committed the crime except that A, someone prevented him from committing the crimes of sexual battery, victim less than 12, and defendant over 18, and or aggravated child abuse, or he failed. The crimes of sexual battery, victim less than 12, defendant over 18, and or aggravated child abuse, it should just be and aggravated child abuse are defined later in these instructions. How does that preliminarily sound?
Good.
Okay, then in the rest of the attempt instruction, it talks about, if applicable, the affirmative defense of defendant abandoning their attempt. Are you requesting that, Mr. Granville?
No.
And then the rest of that goes to the affirmative defense. So I'm going to take that out. Okay, moving to felony murder third degree. Let me copy that. All right, moving on to felony murder, third degree. In order to prove the defendant attempted to commit the crimes of these. Lewd, lascivious, and child abuse. All right, in order to prove that the defendant attempted to commit the crimes of lewd and lascivious battery, victim less than 16, lesser is count 2, and or child abuse, lesser is count 3, the state has proved the following two elements beyond a reasonable doubt: that it did some act toward committing the crimes of lewd and lascivious battery, victim less than 16, lesser is to count 2, and or child abuse, lesser is to count 3. That went just beyond thinking or talking about it. He would have committed the crime except that someone prevented him. All right, let me go print these up so you guys can look at them. Actually, can I use your printer? Thanks. Thank you. Makes it easier. Okay. Should be just two separate instructions. One for first degree felony murder, one for third. Okay, state, let's get these. All right, one for the state, one for the defense. Take a look.
Judge, do you want to make it bold to have it be similar to the attempt to commit?
I can.
The instructions that go back to the jury, they don't have the headlines on them, do they?
Yeah.
They do.
Yeah.
Judge, I see it in the felony murder third degree, attempt to commit crime section. First sentence, there's two ofs at the end of the sentence.
Oh, yeah, I changed that. I caught that.
Okay.
So you talk about the first element?
No, the first, the paragraph?
Right. In order to prove that the defendant attempted to commit the crimes of lewd and lascivious.
Yeah.
Yeah, I caught that.
Okay.
I just changed that. And there's another double of in the 2A. I'll take that out.
Okay, I see it. Judge, in the attempt to commit on the third degree, you have lewd and lascivious.
Oh,
It's lewd or lascivious. Looking at the standard is looking at the legal
Right.
law.
okay. Any other requested changes?
Not all those instructions, no.
All right, any part of the instructions?
No, no, and I do object to the attempt instruction based on it being uncharged conduct. Similar to my objection as to the felony murder.
Okay. I'm going to include it. Okay, let me take a look here real quick.
Word form.
Okay. I'm going to go print them up. Just take me a moment. Let them know I'm printing up right now
Okay.
14 copies of jury instructions. So I'll be with them momentarily.